State versus law involves three guys coming out of a bar at 2 a.m. They encounter a male and female couple. Apparently, some of the three men who are coming out of the bar, I'm not saying that they're intoxicated, but it is Jersey City. It's 2 a.m. and they're coming out of a bar. Someone's mother has trouble with this couple because they're next door neighbors, and as anyone would in a civilized society, there's immediate beatdown. Again, they're throwing fists left and right. So someone hears the disturbance, a cop car rolls up with two cops, and one of the people who are administering the beatdown sees the cops and he starts running away. Now remember, it's just some fisticuffs and stuff. So the cop naturally does what any cop would do in that situation. He fires at the fleeing defendant. And the defendant falls down, I think, out of shock because, as he testified at trial, he felt the bullet go through his hair. How close is that? It went through his hair, but it never touched him, but apparently that was shocking enough. He fell down. So the police officer came over, stomped on his hand, took his flashlight out, smacked him in the back, and then dragged him back to the scene by the hair of his head. He goes to trial, and he's charged with ag assaults and misconduct in office. The jury acquits him of the ag assaults, but they convict him of DP, simple assault, but also that simple assault constitutes misconduct in office. His argument was, hey, this forfeiture statute doesn't apply to DPs. I was convicted of a DP assault. It doesn't count. And he cites a statute in Title 2C that says, look, we just want to make it clear that there's lots of disabilities, you lose your right to vote, et cetera, associated with crimes. But these disabilities do not apply to DPs and petty DPs. So his argument was forfeiture of office doesn't apply to me. And the court noted that his argument was wrong for a number of reasons. Number one, the forfeiture statute specifically references DPs and petty DPs. It specifically references. It just doesn't say it's a consequence of a crime. It says it's a consequence of even a conviction for a DP or petty DP. And then I think at the end they added, not for nothing, you're also convicted of second-degree misconduct in office. You neglected to mention that in your moving papers. So this case just holds that it applies to DPs and petty DPs, and any other statute that might be misconstrued or perverted to seem to say to the contrary just isn't applicable. I know that they say it's a civil consequence, and that's true. And that you don't need to inform someone. If you're a municipal court, and this happens to your client, and he or she goes in and pleads guilty to shoplifting, when they're a school teacher and they didn't realize it. There's an argument to be made here. Granted, it may not be a strictly legal argument. If it's not a consequence that you have to tell a defendant about, why are the plea forms in all criminal cases, why do they contain a warning? If you're a public employee, you're going to lose your office. If it's only a collateral consequence, why did the Office of or Office of the Courts, and why did the Supreme Court mandate that be on the plea form if they don't want you to know, if they don't think it's important enough for you to know? So although it's called a collateral consequence, remember, in Superior Court and even down below, if you're going to pay your fine over time, through the county probation department, let's say, and you pay it, in piecemeal, they have to tell you that there's a $2 transactional fee every time you pay that. So they have to tell you about $2, but they don't tell you that you may lose your $100,000 public employment and your $750,000 pension.